What about now? Test. Audio was gone, but the audio should be on now. Audio's gone. Audio was gone, but the audio should be on now. Yes, it is. Can you please confirm at this late moment? Press the number 9 by confirming do you hear audio. Alright, great. Audio's gone. Beautiful. So with that being said, we're going to go ahead and begin here. Can you record in a courtroom? Beautiful. Alrighty, so what we have here is from the Circuit Court of Cook County. Let me go ahead and zoom in a little bit. Hey guys, Jenny, Teresa, Gator, good to see you guys. In the Circuit Court of Cook County, Illinois, it is hereby ordered that effective immediately, Cook County Circuit, effective June 27, 2024, it is superseded by the following. General Administrative Order 2024-13. Subject: cell phones and other electronic devices. So definitions. Scroll down here. Definitions. Number 1. For purposes of this order, the following definitions apply. Chief Judge is the Chief Circuit Judge of Cook County. Common areas are hallways and lobbies of the courthouse outside of courtrooms and offices. Court offices includes the Adult Probation Department, Children's Rooms, Office of Official Court Reporters, Family Court Services, Office of Interpreter Services, Jury Administration Offices, and Juror Assembly Rooms, Juvenile Probation and Court Services Department, Social Services Department, and other office operations of the Office of the Chief Judge. Office of the Chief Judge. Number 4. Court visitor means An individual present in a courthouse in county. 5. Portable electronic devices are mobile devices capable of electronically storing, accessing, or transmitting information, including but not limited to personal computers, tablet computers, mobile telephones, including cell phones, smartphones, and any form of telephone with a camera and audio and video recording and transmission capabilities, smart switches or smart watches, or similar devices. 6. Portable readers are electronic calendars, e-books, readers, or similar devices incapable of making audio or video recordings. Presiding judge, except as provided by in section 2C. Below is the presiding judge with the administrative responsibility for supervision of Chicago branch of criminal court. The Lython Criminal Courthouse, the Domestic Violence Courthouse, Juvenile Court, a restorative judicial or justice criminal court, or a suburban municipal district courthouse, respectively. Hey Sheila, how's it going? Hello there, Nate, and Good Citizen. Good to see you guys. Number 2. In general, all court locations. In general, all court locations. No person except local, state, and federal enforcement officers on official business shall take or broadcast photographs or make broadcast audio or video recordings anywhere in a common area or courtroom without prior approval of a judge, or as governed by Illinois Supreme Court Rule 44 as amended. Except as provided herein, all court visitors may use portable electronic devices and portable readers in common areas of the courthouse, such as lobbies and hallways. However, all portable electronic devices must be placed in silent mode or turned off at all times within courtrooms and the common areas of the courthouse. Okay, great. It's establishing it must be silent. Section C. The presiding judge has discretion to grant exceptions to the restrictions herein for the common areas of the courthouse. At the Daily Center, a presiding judge of Division of First Municipal Court has the discretion to grant exceptions to the restrictions herein for a courtroom assigned to that division or district, respectfully providing all exceptions are consistent with Illinois Supreme policy on portable electronic devices. So real quick, let's highlight section B. Let's highlight section B. Yeah. Alrighty. So where it says silent, placed on silent. Alrighty. Let's carry on. C, section C. The presiding judge, or actually we're on section D. The judge residing in a courtroom has discretion to grant exceptions to the restrictions herein for that courtroom when the judge is presiding, providing all exceptions are consistent with the Illinois electronic policy. Section E. No court visitor shall use a portable electronic device to communicate or attempt to communicate with any potential juror or jury at any time. Okay. Hey, how's it going? Good. Eyes on the audit. Section F. No court visitor shall take photographs or make recordings of persons or activities in a courtroom or court office from the hallway or lobby. So look at this. No court visitor. No court visitor. Did they define what court visitor is? Let's go back up. We're at section F. 2F. So did they say court visitor? Yep, means any individual present in a courthouse in Cook County. Okay. So go back to F. Shay, hello there. Okay. Section G. So let's highlight section F. This is unconstitutional here. They're telling you that you do not have the right. Look at under section G. No court visitor shall use a portable electronic device. Or section F. No court visitor shall take photographs or make recordings of persons or activities in a courtroom or court office from the hallway or lobby. Oh, okay, I see what they're saying. They're saying of persons and activities in a courtroom or court office from the hallway or lobby. Alright, but that's not in the hallway or lobby. So that's to be construed as the plain view doctrine as well. But section F is something we're going to highlight here. That's another great thing. Section F. No court visitor shall take photographs, right? No court visitor shall take photographs or recordings of a person's or activities in a courtroom or court office. And that's from the hallway or lobby. All right, let's carry on. Section G. Section G. No court visitor shall use a portable electronic device to harass or intimidate any witness at any time. Well, that's true. You know, harass and intimidate is never the answer. So that's pretty much common sense. But here's how they misconstrue things in letter F. Alright, moving forward. Section H. No court visitor shall use a portable electronic device, PED, to communicate with any witness in violation of a court order excluding or what's that? Sequestering witness at the time. Sequester? What's that? Sequestering? Sequestering. I might have to look that up. Okay, Linda, hello there. Great thinkers in the building. Controlling the masses, that is what it's all about, says Linda. Well, people need to inform themselves of their rights, right? Let's go ahead and carry on here. So, yeah, section H is kind of like, you know. Alright, let's carry on. Section I, other electronic devices. Cameras, video recording equipment, and recording devices not classified as... Oh, wait a minute. And recording devices not classified as portable electronic devices are not allowed in courthouse unless permitted by chief judge, presiding judge, or chief presiding, and such conditions as occurred for ceremonial events such as marriages, investitures and graduations in problem-solving courts, or as outlined in Cook County number 2412, extended media coverage, the Illinois Supreme Court's policy for extended media coverage, coverage in the Circuit Court of Illinois Supreme Court Rule 44. So if we need to further address that, we could look at Rule 44. But let's focus at this section here. Okay. Section I. Other electronic devices. Let's go over this one more time. Other electronic devices, cameras, video cameras, video recording equipment, and recording devices not classified as portable electronic devices are not allowed in courthouses. So here they're just flat out saying video cameras. Oh, okay, all right, I see what they're saying. They're saying actual camcorder. They're not in this point here. They're not mentioning not as classified as portable electronic device. So not your cell phone are not allowed. Well, here now you can argue that no, your cell phone is allowed. So you see, this is what you call trickery here. You need to know how to read between the lines. So under section I is what we're going to highlight, so we could reference then our. Okay, great. This is a real great one here. Now let's redefine portable electronic devices, okay? Portable electronic devices means our mobile devices. Oh my God, this is so beautiful that they wrote this in clear light here. And you know what? Here's the thing, that if you ever are recording and a deputy sheriff wants to give you, you know, well, let's continue reading this first. Let's finish reading this. Well, so yeah, cameras, but what they're saying is cameras, actual cameras. They're not saying actual cell phones. They're saying cameras are not allowed in the building, right? So with that being said, it would be impossible almost for them to say, or you know, it would be unethical for them to say cell phones are not allowed in the courthouse. Doesn't make no sense. So number 3, use in courtrooms. Now it's emphasizing on the actual courtroom, right? Where the judge presides. Section A, section 3A. At the discretion of the judge presiding, case participants, including lawyers, parties, including self-representative litigants, and witnesses, may use portable electronic devices in courtroom to check calendars or present case-related information. Okay. Section B, 3B. Members of the news media may use portable electronic devices to take notes or to communicate in writing with news media colleagues unless the judge presiding orders otherwise, to maintain proper courtroom decorum and maintain the integrity of the judicial process. Oh, thank you, Teresa. Thank you so much. I gotta look that up. Well, I was planning on. Thanks for looking it up. Oh, just a disclaimer. This is not legal advice. Nothing in here is to be construed as, you know, any sort of legal advice, or my disclaimer would be to you, don't try this at home. Hey, Brendan, long time no see, man. Ready? Let's go ahead and carry on here. Section 4. Use in court offices. Okay. Now they're emphasizing on the office, court office. Because inappropriate use of portable electronic devices in court offices can be a danger to court visitors, cause distractions or intentional or unintentional disruptions. You see what it's saying here? It's saying in courtrooms can be a danger. It's not saying it always will be, or they can't predict the future. So it's saying that it can be a danger depending on how you conduct yourself while holding a camera, if you decide you want to record your transaction. So portable electronic devices in court can be danger to court visitors. It can cause distractions or intentional or unintentional disruptions in order and process of the courts, or adversely impact the ordinary administration of justice. Oh, that one got to be thought about over. Or adversely impact the orderly administration of justice. That's what some employees do to the people. They impact the orderly administration of justice. That's a good one. Okay. No person shall take or broadcast photographs, make or broadcast audio or video recordings anywhere in a court office without prior approval of the chief judge or presiding judge. So here they are putting emphasis on the word office, court office. Court office means if the employee lets you behind the counter, follow you, or they you follow them into their own office, their government office. That's what they mean by that. Not at the actual counter. This is if a higher up wants to walk you in. Because if we go back to the definitions here, we left off at section 4. If we go back to the definition, common areas differentiates from court office. So number 2 differentiates from number 3. A common area are hallways and lobbies of the courthouse outside of courtrooms and offices. So up until now, we still have not established any fact here or any writing that forbids you to record with a cell phone in a common area. Sure, it may forbid you to record with an actual camcorder. That's what they have in writing, because that's a video camera. But it does not mention with a cell phone up until this point. Let's go ahead and carry on. Okay. So number 5. Use in Illinois Department of Children and Family Services DCFS office. Because inappropriate use of portable electronic devices in DCFS office can cause the unwarranted invasion of personal privacy and unduly increase the risk of irrevocable harm to families and children. No person shall take photographs or make audio recordings of persons within DCFS office without prior approval of judge. Okay, now they're talking specifically about DCFS offices, which I would argue, or whatever, avert that you can, based on the Constitution and the Freedom of Information Act. So let's go ahead and carry on. The Freedom of Information Act allowing you to reproduce digital images of public record. Number 6, confiscation or equipment ejection. Beautiful. Court visitors using a portable electronic device, which means a cell phone, or possessing electronic devices in violation of this or any court order. Great, they're established everything above this, which we know what is referenced here. May be held in contempt of court. You may be held in contempt of court and are subject to penalties as provided by law. Any portable electronic device used in violation of an order may be confiscated and held until all investigative and court proceedings are concluded, at the discretion of the chief judge, presiding judge, or the judge presiding. Any unauthorized, this is all unconstitutional here. Okay, so any unauthorized audio or video recording of photographs shall be preserved until all investigative court proceedings are concluded and shall be then deleted from the device. Oh my God. Well, what they're saying is no deputy sheriff can delete your stuff until the judge has seen it and made that ruling, So court or determination, court personnel shall not be responsible or liable for any damage to or loss of a confiscation portable electronic device. Hey Brendan, this is the state of Illinois. BJ Allen, long time. Does anybody have any questions here? We're moving on to number 7. Additional restrictions. So let's finalize on number 6. What we established is nothing in what we read from number 1 through 6 forbids you from recording in the lobby, which means at the counter where the clerks are there to serve the people. They're not forbidding you to do that. Nowhere in here. Now, the deputy sheriffs, they might be belligerent and they might still put hands on you and just say it's against the law, just those 4 words, right? But that'll be a violation not only of your constitutional rights, but of this exact order here. Because it's easy for a deputy sheriff to violate your right by saying 4 words, which is, 8 words, which is you're violating this order, put your confiscate your phone, or put your hands behind your back, you're under arrest. So those are 8 words that they tell you versus you have the actual 5-page evidence in your hand and it does not apply. They might not want to argue at that time, but that's why you call a higher up, because they might have more wherewithal. They deep down in their heart, they probably know about this stuff, but they test to see if the member of the public is capable of standing and asserting his rights. I think you jumped the gun here, Teresa. What number are you referring to of possessing can confiscate your device at the entrance of the courthouse? Moving along, number 7, additional restrictions at the Lyington Criminal Courthouse to avoid interference with the administrative of justice or threats to safety or security to court visitors, except as noted below. All portable electronic devices and other electronic devices are prohibited in the George Norley in the 26 North California. Okay, great. We're going to skip over this because that's applying to the court, that's applying to the jail. So we're going to skip over number 7, as this time this is, to be referenced at a later time. Now we're going into number 8. Persons at court locations. As a matter of fact, you know what? We're not going to skip it. We're going to go ahead and read it. Let's go ahead and read it. So number 7, it's forbidden to record at 2600 South California Jail. Section A, the following persons, all of whom must have proper identification and be on official business in the courthouse and authorized to possess portable electronic devices and other electronic devices. Social visits and business for purpose of addressing one's own private personal interests are not considered to be official business. Current or former judges, licensing attorneys, authorized employees of attorneys, has been authorized by the Chief Justice, Chief Judge, Presiding Judge, or the Judge Presiding. Members of the news media. Okay, well, like I said, yeah, never mind. You guys could read all this section. We're going to skip number 7. We're going to jump into number 8. Persons at court locations other than the George North Lytton Criminal Courthouse may use the telephone, SMS, short message service, texting, instant messaging, email, and word processing functions of a cell phone or other electronic devices only in the public areas of the courthouse outside of the courtrooms. This is the one that I like. And said electronic devices must remain off when in courtrooms. Oh, this is the one that clears everything up. All right. So they intimidate you at number 7. And then they remind you of the freedom you have at number 8. Alright, so let's continue. Unless expressly permitted. Well, this is saying, and said electronic devices must maintain off in courtrooms unless permitted. Okay, so this is number 8 is where it's telling you. Number 8, let's read number 8 again. Persons at court locations other than, so this is saying all other locations except for the jail, the courthouse, may use telephone, right, text, and word processing of a cell phone or other electronic device. Here's the key word. We may or other electronic device in public areas of the courthouse outside of the courtrooms. Okay, great. They had to make themselves clear here. Let's carry on. This is amazing, man. Number 9. Nothing in this order shall be construed to the effect to affect a judge's authority to permit attorneys and self-represented pro se litigants with cases before a judge to use such devices in courtroom. Again, they're emphasizing on courtroom for purposes of such making evidentiary or other presentations to the court, preparing orders and other court documents, making entries in case management application, or any other purpose the judge deems appropriate. Notice that this is the only page that's shaded. Everything else was white. Number 10. Nothing in this order shall be interpreted to restrict recording on the outdoor premises of a courthouse. Unfucking believable. Provided the recording activity does not disrupt court operations, obstruct access to or from the courthouse, or compromise the confidentiality, safety, or security of all court visitors. Number 10 is another reminder of freedom, telling you that you do have the right to record in the common areas. Okay? In the common areas you do. Here they're saying you do not have a right to record in the courtroom unless you have permission from the judge. So that's very clear here. Points 8 and 10 are the most powerful in here. Let's read number 10 once again. Nothing in this order shall be interpreted to restrict recording on the outdoor premises of courthouse, which you're talking about, common areas, lobby, the counter, provided the recording activity does not disrupt court operations, right? If you're peacefully recording, or obstruct access to or from the courthouse, you're not standing in anybody's way, or compromise the confidentiality, you're not standing over people's info, or safety, you're not a safety violation, or security of court visitors. You're peacefully filming, you're peacefully exercising your constitutional right. Number 11. This is an amazing thing right here, man. All right. Number 11. Pursuant to Illinois Supreme Court Rule 44, nothing in this order shall be interpreted to permit the taking of photographs or broadcasting audio recordings in the courtroom. Here again, courtroom, or of the proceedings conducted by video conference during sessions of the court recesses between proceedings, or the broadcasting of television of court proceedings unless authorized by the judge, or judge presiding permitting extended media coverage. So here they're telling you in number 11 that they will broadcast your face and the judge and everybody else's face on their device, but it's forbidden for you to record that. They could put you out there, but you can't record your own appearance, is what they're telling you. Let's go ahead and carry on to number 12. Any person in violation of this order might be subject to prosecution for contempt of court. Nothing in this order shall be construed to infringe upon the authority of the Cook County Sheriff. Well, nothing in this order shall be construed to infringe upon the authority of the Cook County Sheriff or the judge presiding to deny courthouse or courtroom access to any person in interest of public safety. Okay, number 13. We're going to get into comments in a few seconds, guys. Number 13. The sheriff of the Cook County or his or her designee or any peace officer shall enforce this order by casting violators of this order to appear before the court for a hearing and for the imposition of such sanctions as the court may deem just and proper. That's so fucking cute. The sheriff of Cook County or his designee, one of his deputies, or any peace officer shall enforce this order by causing violators of this order to appear before the court for a hearing. That's amazing. This order supersedes General Administrative Order 2012 and 2013, dated the 27th of August 2024. This is entered by the Chief Judge of Cook County, stamped and signed, along with the signature of the Deputy Clerk. Okay, great. So, anyway, this was an amazing read right here. Teresa made a good point. This is why you have to keep this in your binder at all times. So, they will try to test you. They will try to trip you up and hem you up. And if you don't know what your rights are, if you don't know what this order actually entails, the best thing for you to do is read through and highlight it, and you will ensure yourself that they are unable to forbid you from recording government officials in the official course of their duty, as long as you're in the common area, common lobby. And they go over that in point 10 and point 8. So this is a great read. This may be similar in every other state. This does only apply to the state of Illinois. But then again, yeah, this. As a matter of fact, here's what we got to do now. We just punched a hole through these 5 pages here. We printed them out. We're going to include this in our binder. And with that being said, thank you guys all for coming in here. I read some of the comments. Thank you guys for participating in this great read here. Don't ever be distracted from your rights. Don't ever allow a law enforcement officer to abuse his authority by just shouting at you and telling you that you're in breach of this order here. Those are just 4 words he's going to tell you. You're going to have the 5-page with you highlighted, explaining to him on his body cam that it does not apply to your peaceful exercise of your rights. Other than that, guys, man, again, thank you guys for coming in. It was a wonderful read. And be on the lookout for in a few more days we will be releasing new content. The one who encourages you to audit them. Plenty love.